Okay. We have gone through this bill and it is now up to draft 1.1. And it's grown to 9 pages from 7 pages. That's what I can tell you. So, Rebecca Wasserman from Legislative Council is here to walk us through the latest draft.
Mr. Chair, is this 163?
Yeah, what did I say?
That's okay. Just a note to Peggy, I clicked on it on the website and it takes you to an error page.
Oh, really?
Yeah, so I don't know what's up with that.
Let me
I just did that and I didn't get that.
Let me try again.
Share the document if it's not up.
No, it tells me that the page doesn't exist when I click.
That's weird. Can you try again? Because I just clicked it and it works fine.
No, not for me.
Huh. I'm
Um,
not sure. I can
I mean,
repost it.
if Becky's going to share the screen, it won't matter. I just wanted to let you know.
Yeah, I don't know. It's very strange because it's.
Well, why don't we share the screen just because there is some technical difficulties.
Hey, your committee assistants hang out somewhere where they're not in committee?
No.
I saw Alex earlier this morning, but I haven't seen him since.
Oh, you know what? He's over in health and transportation.
Oh, okay.
Can everyone see that?
Yep.
Okay. Let me just. My Zoom is not cooperating. Okay, I'll just go with what I have here. Becky Wasserman, Legislative Council. This is a strike-all amendment to Senate Bill 163, which was titled as introduced an act relating to state court jurisdiction for special immigrant juvenile status, but that title has changed in this version of the bill, of the amendment. So I can, there were some global changes throughout that I think might be helpful to just mention before I start. So in the bill as introduced, the reference to the child who was petitioning for special immigrant juvenile status was a at-risk non-citizen child, and a change that was made throughout this this amendment is to refer to those children as vulnerable non-citizen children. So you'll see that change throughout. And then there are also the primary changes throughout also deal with, I guess not expanding, but amending the definition of court to make it clear that the courts that can review these petitions and make special findings for children will have jurisdiction over the child in other circumstances than just probate and family division, and that these findings that are being made are findings that are within the jurisdiction of that court and not necessarily just being done because a child has made this type of petition.
Becky, this is Joe Betting. Could you just back up to line 19 on page 1 and tell me what the difference is between citizen and citizenza?
Oh, the version that you have, the paper copy, has a spelling error, and I had sent Peggy an updated version, which is what is reflected on the screen and will be on the website.
It is on the website.
I can't quite read it from this distance. What is citizen or citizens? Okay.
Yeah, so the definition of child or children. So it's referring to someone who is unmarried individual or individuals who have not yet attained 21 years of age and who are not yet a United States citizen or citizens.
Still sounds kind of strange to me, but Philip's the English major.
I think it looks okay.
I think
Well,
it's
that
because
seal
the
of approval,
definition
I
is.
think we move forward.
So this is actually one of the changes that were made, is in the definition of child in subdivision 2 on page 1, adding to the definition that along with being an unmarried individual or individuals who are not yet 21, that the child is also not a United States citizen or citizens, plural or singular. And I just wanted to point in subdivision 1, there's a definition of vulnerable here, and that is replacing that reference to at risk that was in the previous version. The next change is in the definition of court, which is what I mentioned, that the court now means any court that has jurisdiction over an unmarried individual or individuals who have not yet attained 21 and who are not U.S. citizens, and that includes the probate division and the family division of the Superior Court, but that is meant to also include other courts that might have jurisdiction over a child in this situation for another reason. And so in terms of going through the amendment, do you want me to just go through where there were changes from the previous version?
Yeah, highlight the major changes.
So in subsection B, there's no, this is just sort of reiterating what I mentioned before, that the clarifying that the court that's reviewing this petition has jurisdiction under Vermont law to make judicial determinations regarding the custody and care of children, but is not, it's not specific to the special immigrant juvenile status under federal law. It's just that these courts under Vermont law have this jurisdiction over a child. Subsection C, the procedure for a petition. So when a vulnerable non-citizen child or a person who is interested in the welfare of that child petitions the court, the petition for special findings has to include all of the requirements for what is in the federal legislation for special immigrant juvenile status, but this section no longer, so it follows what's required in the federal law, but it no longer refers to just special immigrant juvenile status. It is, again, a little bit broader that any court that has jurisdiction over a non-citizen child in this circumstance would be able to make these petitions, or would be able to make these special findings.
Can I ask a question, Alice?
Yeah.
I'm just wondering, could this also apply to a child in another country?
I think the intent here, and I'll let some other folks jump in on that, but I think the intent here is that this is a child in the United States who is making this petition to apply for, who's making this petition for special findings, which will allow them to stay in the United States if they are granted special immigrant juvenile status.
I guess the piece doesn't say stay someplace. I'm thinking of a family who is in the process of maybe adopting a foreign child, and things fall apart before the child gets to this country. Even though they've done all the paperwork and all of that, could that child come under this provision?
I think if they're adopting a child, then that child would become a US citizen through that adoption.
I'm
So
talking
this
about,
is,
yeah,
sorry.
yes, I'm talking about before they get to this country and become a citizen. I'm talking about something happens in the child's country of origin before the child gets to the United States.
My understanding is that this would not be available in that circumstance, but I can defer to those who
We
might
have
be
a
on the
number of
call.
Aaron or Rebecca or anyone else want to comment on that?
So I would be happy to comment on that. Good morning, everybody. Special immigrant juvenile status is something that non-citizen children can only apply for once they're in the United States.
Okay, thank you.
Thank you.
But to follow up on that question, if I could, Senator Sears,
Yep.
shouldn't it be restricted to children who are residing within the geographical confines of Vermont?
So I don't know if I'm the best person to answer this. This could be a question about state court jurisdiction, Vermont state court jurisdiction in general. Would a Vermont state court have jurisdiction over a Mexican national living in Mexico? I don't believe so. And this bill certainly is not intended to change that.
Nope, it's Rebecca Turner from the Office of Defender General. I'm sorry. Just for the record, you at least once just state your name so that the record can pick up who you are.
Thank you, Senator Sears. I agree with what Aaron Jacobson is saying. In terms of whether or not the Vermont courts having jurisdiction over juveniles could reach to that juvenile outside of Vermont. Again, we have Judge Zone here and others here with DCF who can weigh in, but I don't see that being the case again. And I don't think that it's necessary to add that language, Senator Benning, because of how the definition of dependent on the court, page 2, lines 3 and 4, that is a required finding for these state courts. And to make a finding that a juvenile is dependent on the court means that the person is subject to the jurisdiction of the Vermont court. So it's built into the definitions themselves, this threshold requirement that the state court be able to invoke jurisdiction over the child. Now, here, what we are trying to do is merely make sure it's clear that that jurisdiction extends to youth who are between, over 18 and not yet 21. And so that, again, that overall objective of this bill remains unchanged and really is the narrow focus here.
Any other questions of where we've been so far, which is we're on line 4 of page 3, I believe. And we just had an explanation of that section.
I keep going then?
Yep, please.
So the rest of that section has not substantively changed. It is just laying out what needs to be in the findings that the court will is being asked to issue in the petition. On page 4, line 6, under additional findings, what was added here is that if requested by a party, a court may make additional findings that are supported by evidence, and Vermont law was added to that.
Can I just ask a word about the use of the word abandonment? So let's just, my understanding is a child is here, came with a mother, for example, got to Vermont, she was a dairy worker, is because of immigration is sent back to whatever home country she came from. Is that abandonment? I mean, I don't think she abandoned the child. The ICE did. Is there another word that could be used there?
So I think that this is lining up with the language used in federal law. How the court interprets that may be something that Rebecca or Erin or Jill might be able to answer better than me.
This is Rebecca Turner from the Defender General's Office, for the record. I think that abandonment is interpreted broadly, and to the extent that Senator Sears, your concern is that it was not willful abandonment by the mother, and that could be a factor. Yeah. The language here is broad and it already includes or similar circumstances, right? So unable to care for the child because she's been physically prevented in that instance by U.S. government officials removing her. So I think that your concern that we need to maybe broaden that language is already there. And I'm speaking, Rebecca, I think I'm looking at page 3, line 7 on this latest draft 1.1. Again, it goes to underline abandonment, abuse, neglect, or similar circumstances.
Okay. Well, that helps. Thank you.
On page 4, subdivision 3, under health, safety, and welfare considerations. So this section is saying that in making a determination of whether it's in the best interest of the child to be returned to the child's home country or the parent's previous country of nationality, the court will consider health, safety, and welfare considerations. And the language on lines 8 through 10 was added that the health, safety, and welfare of the child must be of paramount concern when the court considers the best interests of the child.
Okay.
The next few sections, some language was removed here and added to section 2 with respect to extending the guardianship for children who are over 18, but have not yet attained 21 years of age. So I'll get to that a little further along, but that was another sort of major change to this amendment, was that all of the language was in Title 14, and this amendment adds some new language in Title 33 with respect to the extension of the guardianship for those youth over the age of 18.
Cool.
The notice requirement in subsection D removed a reference. Sorry. Oh, I thought I heard a question. On subsection D at the bottom of page 4, removed a reference for when trying to find the identity or location of the child's parents. The court has to serve notice, and the previous version referred to providing this alternative method or service or waiving service if the child sort of fit the description of what was in the federal law for a special immigrant juvenile. And this removes that sort of cross-reference to the federal law here.
But it's a may, not a shall, correct?
It's in the court's discretion to decide to provide an alternative method or service or waive service. So it's a may.
Judge Zone, okay with that?
We have no issues with that. I would note that the one section that I did have a concern about was the one that said guardianships, because it talks about a guardianship pursuant to it says, for purposes of appointment of a guardian of the non-citizen child pursuant to this section, but this section does not appoint guardians. As Ms. Wasserman said, that's done under Title 14. So I think the language, if it said for purposes of this section, comma, the term child or minor shall include, if you remove the language that says appointment of a guardian of the non-citizen child pursuant to, I think that cleans it up and makes it clear that the appointment is done under Title 14 and not 33.
Okay. That was Judge Zone for the record.
I apologize. Thank you.
No, that's fine. I'm just, we're trying to be informal, but at the same time, somebody checks back to the record and wants to know who just spoke. Okay, well, moving right along.
Okay. Subsection E, expeditious adjudication. And a question came up about this in last time I testified about, it says that the court shall hear, adjudicate, and issue findings of fact on any petition for special findings under the section as soon as it is administratively feasible and prior to that child turning 21. So a change here was made that says that the court shall do this when it is in the best interests of the vulnerable non-citizen child. So it does give the court some discretion of determining that it's in the best interest of the child to hear the petition and issue the findings as soon as it is as administratively feasible. And then on page 6, the construction section of the bill on line 4, subsection H, this was changed from this section shall be liberally construed to be in the best interests of the child, and it was amended to be liberally construed to its legislative purpose. And then section 2 is all new language, as I mentioned. So this is adding in Title 33, the guardianship language, which says a new section, retention of jurisdiction over certain vulnerable non-citizen children. So subsection A uses the same definitions that were in Title 14 with respect to vulnerable child and non-citizen. And then subsection B is saying that the family division may retain jurisdiction over the non-citizen child who has not yet turned 21 for the sole purpose of adjudicating a petition for special findings and making judicial determinations regarding the custody and care of the child consistent with this section. Nothing in the section expands the scope of the court's jurisdiction to order a youth into the custody of the Commissioner for Children and Families pursuant to this chapter. The procedure for petition in subsection C is similar to what is laid out in Title 14. So the child or a person interested in the welfare of the child may petition the court for the special findings to obtain relief from the underlying abandonment, abuse, neglect, or similar circumstance. There's a cross-reference here that says in accordance with the procedure in Title 14, Section 3098, the court reviews that petition, including affidavits and other evidence, issues the finding of facts, and makes relevant conclusions of law consistent with Section 5101 of this chapter. And that is the purposes section that has the best interest of the child laid out, set forth in that section. Subsection D is the expeditious adjudication with respect to this to Title 33. So it says, when it is consistent with the purposes as set forth in section 5101 of this chapter, which is the purposes section of this title, the court also can determine that it shall hear the case and adjudicate and issue the findings on any petition for special findings for a child prior to them turning 21 years of age. Subsection E is duplicating the language in Title 14 about the additional remedies under Vermont law and similar findings of fact. So a child is not limited under this section from petitioning for special findings for any other petition under another provision of law for any other rights and remedies that's available to that child. And then in subdivision 2, it says that the section shall not limit the court from issuing similar findings of fact or conclusions of law in any other proceedings concerning that child. In any subsection F says that in any judicial proceedings in response to a request that the court make special findings to support a petition, the information regarding the child's personal information such as immigration status, nationality, place of birth is protected by state laws and remains confidential. And this confidentiality and exemption from the Public Records Act is also in the language in Title 14. And then the effective date is July 1st of this year. And then finally on lines 9 to 10, the new title of the bill is an act relating to state court petitions for vulnerable non-citizen youth.
Thank you. That's helpful. And my understanding is you work closely with several folks, and particularly from the Office of Attorney General and the Office of Public Defender. So I appreciate their input and their help with this. Are there any comments from anybody who's in the audience? And the only change I've heard so far is proposed by Judge Zonay. Is that right? So anybody who would like to speak, if you could take that down now, Becky, thank you.
Senator Sears, I have a
Yes.
question.
Good.
Becky, if I'm reading this correctly, I'm just going to throw out a scenario here. St. Johnsbury has a resident mom without the child, but over in Littleton, New Hampshire is the father with the child. Child is now 20 years old. The father leaves. There is certainly the possibility that ICE could come along and say, we're going to bring the child back to country of origin. If I understand this correctly, the mom could petition a Vermont court and make a claim that whatever the past living conditions were in the previous country were threatening to this individual's life in some fashion. Am I reading that correctly?
So I think that there's needs to be the child's health. The child needs to be considered vulnerable. So the child's health, safety, or welfare has to be in jeopardy due to abuse, neglect, abandonment, or similar circumstance. And that the child's return to the country of origin would not be in the best interest of the child. So I don't know in this scenario what the child's circumstance would be, but they would have to meet the requirements that their health, safety, or welfare is in jeopardy. So I guess I'm saying, I don't know if the mother in this scenario, just because a father might not be, might have been deported in this scenario, I don't know what the situation is with the child's mother And I can let somebody else speak to that who actually would be practicing in this area, but that's my reading of the situation. I think it would be specific to the circumstances of that child.
Anybody
I'm
else?
assuming- I'd just like to lay out the scenario properly so I can get a good answer. If the father was providing food and shelter for the 20-year-old because the 20-year-old cannot speak English, was unemployed, etc., and the father leaves, if I read this correctly, the mother could petition the Vermont court to demonstrate that this 20-year-old, now considered a child, is in danger of their health or safety or their welfare being affected. The mom could go into a Vermont court and make an argument that, number one, that child is in fact in some kind of welfare concern. And she may provide evidence that the country of origin was, for instance, gang-related activity. That's why they left, and this child would be threatened with being brought into the gang. If I read this correctly, that scenario could actually be accomplished with this piece of legislation. Am I incorrect?
So I think where I might need a little help with this is that I don't know that Vermont would have jurisdiction over that child in this situation because that child is living in New Hampshire. So I think that there would need to be a situation showing that once the father has left for some reason, if that child needs to be under a guardianship for some reason, if that guardianship was transferred to the mother in Vermont, then a Vermont court would then have jurisdiction over that child. But I think there would be a few steps that would need to happen. It wouldn't be an automatic situation for my reading of this.
Yes, I'm assuming the mother would be acting to either go through probate court or petition a family court pursuant to this legislation to get that child into a Vermont court. And that was why I raised the issue before about the Vermont court as opposed to any court. I just want to be clear that if we're going to enact this, we have a full understanding that the scenario I've just laid out could actually happen here.
I think if the mother in Vermont, if there was a reason for that child to be in a guardianship situation and the mother, and there was a petition for that in Vermont, as part of that, the court would have jurisdiction over that child. So these special findings could be made in the court at that time, but the child would also have to meet these requirements to receive those special findings. It wouldn't be automatic just because the child was the guardianship was being moved over to Vermont. The child would have to meet the other requirements of being, a non-citizen child who was, subject to some kind of abuse, abandonment, or neglect or other circumstance, and it would not be safe for that child to return to their home country or their parents' home country.
I could be wrong, but Judge Zoney, I'd like a little help here. It seems to me this bill is providing Vermont with jurisdiction over that child if the appropriate circumstances could be alleged by the petitioner, mother, who is in St. Johnsburg.
Tom Zoney?
Yep, go ahead, Judge.
Right, so Tom Zoney, Chief Superior Judge. Senator Benning, I think you're correct. And I would just highlight that I'll use the word, the rub here is that I think Senator Benning, you and myself and others may be thinking about, well, Uniform Child Jurisdiction Acts. And do we have jurisdiction over a child who lives in New Hampshire? The UCCJA that's set forth under Title 15 specifically defines child as an individual who has not reached age 18.
Correct.
And so this presents a unique circumstance that it doesn't fall under what we would traditionally look at as jurisdiction for a child. And so I think that it would permit a Vermont court if that mother comes in and says, I have this 19-year-old and they can meet both factors, the abandonment, let's say, and the abuse perspective, and the second perspective, I think, yes, it would appear to provide the Vermont court with jurisdiction to go forward. And again, the traditional UCCJA would not kick it out because the child's over 18.
Thank you. I'm just trying to make clear exactly what the potential is and what we're doing.
Okay. Any other comments, questions, concerns?
If I could just comment briefly, and because I didn't say this before, Aaron Jacobson, Attorney General's office. So Senator Benning, under your scenario, right, that 19 or 20-year-old child, maybe because, as you mentioned, does not speak much English, and previously his father was helping provide his food and shelter and taking care of him, might feel the need to move to Vermont to be with mom. At that point in time, if that 20-year-old consented, mom could file for a guardianship in Vermont State Court. And then if that guardianship is granted, then as well, mom or the child could petition for the special findings that are laid out in this bill. And if the child could obtain those special findings, that would allow him to then apply for special immigrant juvenile status with the Federal Immigration Agency. So that's how that would look procedurally.
Aaron, if I could follow up, in your statement, you said if the child conceded. What if the child does not concede? Now we have a parent coming in under this statute that seems to me to override any decision about this 18 or 19 or 20-year-old conceding to have it happen. And I don't want to walk away from the discussion thinking everything's going to be hunky-dory. I'm just trying to cover all bases.
Sure, I think it's a great question. The way I read this bill, I'm looking at page 4, line 15, guardianship. And we're talking about children who are over 18 here. So it says, for purposes of appointment of a guardian of the non-citizen child pursuant to this section, the term child or minor shall include a person who is less than 21 years of age and who consents to the appointment or continuation of a guardian after 18 years of age. So after age 18, then that youth, over 18 youth, who's also under 21, would have to consent to that kind of guardianship.
Okay.
Okay, thank you.
Any other comment, questions?
Senator Sears, if I may, this is Rebecca Turner
Yep.
from the Office of the Defender General. I just
Please.
noticed, Rebecca, just a typo on page 1, line 15. It's written here in the version I have, child's parents' county of origin, and I think that was supposed to be country of origin.
I'll address that. Thank you.
Okay, sure. And I also, for the record, wanted to say that Judge Zone's suggested correction certainly is amenable from the Defender General's perspective and would support making that change.
Okay. Thank you. Any other comments, questions about this draft with the one change? No. Everybody's okay with this? Yeah, I mean, in the room.
Senator Sears,
Yes.
this is Jill Rudge, clinical professor of immigration law from Vermont Law School. I'm just offering a comment that Vermont Law School's immigration clinic supports this latest iteration of the bill, including the amendments proposed today. Thank you.
Thank you. Anybody else? Jennifer from DCF, any concerns or that you'd like to express?
No, thank you. I've worked with Erin and with Rebecca, and we got the language in around not expanding the scope of custody for DCF. So DCF is comfortable with this, and we're comfortable proceeding with this when we do have custody of a child already. We just didn't want it expanded.
Okay. Hey,
Thank you.
I wanted to take a brief opportunity to thank Rebecca Wasserman for working with all of those folks that are here on the line right now to get this into some shape that is that can work for hopefully a small number of kids, but that may need the special immigrant status. So with that, is there, this would be draft, I'm assuming 2.1 or 1.2, is you have to make a minor change.
Yes, it would be draft 1.2, and I would be correcting the spelling mistake on page 1 from county to country, and I would be striking out in the guardianship subdivision on page 4, the appointment of a guardian of the non-citizen pursuant to. So it would say, for purposes of this section, the term child or minor shall include.
Is there further discussion on this? And is there a motion to report favorably or to amend S-163 as presented in draft 2.1? Senator White has moved that we report this favorably. Is there any further discussion or report the amendment? We amend the bill. All right. Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator
Yes.
Peru,
Yes.
Senator Sears,
Yes, thank you. Is there a motion to report favorably as amended? Senator White,
I will, and can I just say that bills like this never get, they're not glitzy and they don't get a lot of attention and stuff a bit from the press or from anybody else, as a matter of fact, but they make a huge difference in the lives of those that they touch. So I think that it's really important that we spend the time doing these kinds of bills, even though they don't get the press that all those high profile bills get. So I will.
Well said, Senator White. I totally agree. I think any further discussion? If not, Senator White has moved report S-163 as amended favorably to the Senate. Peggy, would you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Peru,
Yes.
Senator Sears,
Yes, it's great. We're unanimous, and I thank all of you very much. Who would like to report this bill? Recognizing you may not get headlines.
I'm happy to do it if somebody will help me. I'm assuming that I'll be out of my stupor.
I'm sure that Ledge Council and folks that are here on stage will be more than happy to help you with the report, Senator White. So,
Thank you.
yeah, it's kind of an abstract area that will, and I think you said it well. So I will leave it at that. And thank you very much. So Peggy, you'll get the copy to Senator White at some point today.
Yep, as soon as I get it, I'll get it from Becky first, correct, Becky?
I'm about to send it to you.
So while we have Judge
And any of the
Zone here.
people that testified want to send me any
Yep, will do.
poignant statements, please feel free. Thanks.
Peggy, while we have Judge Zone here, and before we go to the break, I believe you do have Justice Warple's nomination now.
I do.
So why don't we set for next Friday? We're going to have a very limited hour. Why don't we set her confirmation for next Friday?
9 o'clock.
If it works for the justice, and I'll let Judge Zone work that out with her and you, Peggy, and then we could do our confirmation hearing a week from this Friday. A week from this Friday, not this Friday.
I will let Judge Waples know that it would be the 18th at 9 a.m. Is that in person or is Zoom permissible?
Zoom is going to be permissible on the 18th. After that, we don't know.
I'll let her
We're
know.
waiting further instructions from the leadership of the Senate, but I can definitely say that we will be Zooming on the 18th.
I will let her know. Thank you.
All right. Or a hybrid of that, I should say. Okay, well, why don't we take a break until 11 when we take up S-140, which is Senator Baruth's bill, and we held off on voting on it until he got back.
Much appreciated.